So, in this particular scenario, the case of the Standard Chartered Bank in the suit is that having purchased bonds of face value of rupees uh, 72.5 crores on 19th of February 1992, the SCB consequently received from Citibank original Bias 47 dated 19 February 1992 of the face value of rupees 52.5 crores. Thereafter, on 4th March 1993, the Standard Chartered Bank discharged and handed over the original Bias 47 to the Citibank station. Against the same, Citibank issued to the SEB fresh BR 47 of face value rupees 22.5 crores, and this was subsequently delivered Canfina BR 1401, dated 30 December 1991, of the face value 50 crores. It was contended that endorsement and delivery of Canfina BR to SEB was on the footing that Canfina would honor the same. At the best, the delivery of Canfina beer was merely conferred to an authority on SEB to receive bonds from Canfina, and it was an implied term of the agreement between Standard Chartered Bank and Citibank. And it was mainly revolving around that if for any reason the Standard Chartered Bank did not receive bonds from Canfina, Citibank's obligation would continue or would stand revived. The case of the Citibank is in its written statement is that the FPB duly discharged original BR 47 dated 19 February 1992 of the face value 72.5 crores on receipt of Canfina BR 1401 of the face value 50 crores. The Citibank Fresh BR 47 dated 4th March 1992 of the face value rupees 22.5 crores was duly encashed that the aforesaid discharge of Citibank original and the receipt by SCB of Canfina BR 1401 was unconditional, and the Citibank was discharged of its obligations in respect of transaction dated 19th February 1982. That the Citibank was under no obligation to deliver the securities or the amount thereof, and in any event, right or wrong, if any, of the SCB was only against Canfina itself. That the SCB should take any action against Canfina still is up in the wind. On the pleadings of the parties, the following issues were framed by the Honorable Court. Whether the suit is not maintainable and should be dismissed if non-joinder of Citibank Financial Services. And secondly, it is whether upon the original banker's receipt 47 being handed over duly discharged to the defendants, the plaintiffs cease to have any right in respect thereof or for the IRFC bonds of the face value 22.5 crores mentioned therein, the said discharge being in view of the plaintiff accepting unconditionally of the defendants in the said Canfina bankers receipt for rupees 50 crores as well as the defendants bankers for the IRFC bonds of fairly 22.5 crores are allegedly in the paragraph 8 of the written statement. And whether there was any established and accepted market practice to deliver and accept bankers' receipt in uh, ineffective discharge of the obligations to deliver physical security physical securities as per the paragraph 6C and paragraph 12 of the written statement. Whether and also whether the plaintiffs are stopped from denying that the defendants have discharged their obligations in respect of the IRFC bonds of the face value rupees 50 crores, or from contending that the defendant's obligations in that behalf remains outstanding or subsisting as alleged in paragraphs 3 and 12 of the written statement. In order to come to the conclusion arrived at issues 2 and 4, the special court relied upon its own decision in suit number 22 of 1994, dated July 1995, and suit number 20 of 1994, dated July of 7th July of 1995, and between the same parties relating to another set of transactions. The orders passed by the Special Court in Civil Suit number 22 of 1994 and Civil Suit number 20 of 1994 were the subject matter of Civil Appeal number 7941 of 1995 and Civil Appeal number 8340 of 1995. Since the Special Court in the impunged judgment had relied upon its own judgment in suit number 20 and suit number 22 to decree the Standard Chartered Bank's suit that the facts of the present case are identical to the facts in civil suit number 20 and 22. And it would be necessary to refer to the facts of those cases in detail before proceeding and examining the submissions made by the respective learned counsel appearing for the parties in these appeals. In those cases, also the SCB had a transaction in securities with Citibank on 18th and 19th September 1991. In those cases as well, the original SGL transfer had been from which the transactions had been committed by Citibank to SCB, and through which the exchanges were allotted through another SGL of a smaller amount through Citibank, as well as the SGL transfer form issued by CMF to the Citibank. SGL transfer forms of the CMF were handed over to the SCB on the basis of a letter issued by an officer of the SCB. Namely, SCB filed suit number 22 against the Citibank and Canara Bank, who are trustees of CMF. One of the questions which arose for consideration before the special court was whether the mere handing over of the SGL transfer form would lead to any discharge of liability. It was held that mere handing over of SGL transfer form would not amount to discharge of the original consideration. There could be no discharge unless there was a satisfaction. The Special Court also held that Section 41 and not Section 62 and 63 of the Indian Contract Act would be applicable in the facts and circumstances of this particular case. The plea of the Citibank that the discharge SCL was coming from its possession or custody, and a rebuttable presumption should be raised against SCB under illustration of Section 114 of the Indian Evidence Act. And as the Standard Chartered Bank had failed to rebut the presumption by leading any evidence, it should be deemed that Citibank was duly discharged of its obligation. But this was rejected consequently. Similarly, the plea raised by Citibank that an adverse inference should be drawn under illustration of the aforementioned Section 114 against SEB had also failed to produce a disclosure of the material piece of evidence which would have thrown much light on the issue in the controversy. Um, the court also held that there could be no discharge unless there is satisfaction, and the SCB could sue the Citibank on its original consideration. A failed attempt was made in the end to contend that even if the court comes to the conclusion that, as a matter of fact, Citibank is discharged under Section 63 of the ICA, the decree should not be reversed and the same should only be modified by this court in exercise of its special jurisdiction under Article 142 to do complete justice between the parties. In case both the decrees in suits number 24 and uh, suits number 24 and 1 of 1995 reversed, Canfina would be unjustly enriched and SEB would lose 50 crores with interest, and such a result would be contrary to all notions of justice. It was contended that, irrespective of any view, this special court, may take on documents that the court has power to do complete justice between the parties, as per Article 142 of the Constitution, by maintaining a decree in favor of the Standard Chartered Bank. Acceptance of the submission of SCB would be that this court would be passing a degree against Canfina indirectly. Submission of SCB that, since a decree has been passed in the contingent suit, to the extent of decretal amount paid in the contingent suit filed by the SCB should be decreed, and This proposal was not accepted at all. A similar submission was rejected after an elaborate discussion by the judge in Citibank's case, which I mentioned before. So that concludes my analysis. Thank you.